Good afternoon, students. Today we are going to finish the discharge of contract. Before that, yesterday is a briefing session, and today's I will going to finish the balance portions. So what we see yesterday, the discharge of a contract. Discharge is what is meant by discharge? Discharge in the sense means it is the cancellation, or one person need to perform, the other person is not at all performing, then other person refuses to accept that thing. Then in such a case, what is the issue? That is the void contract or void agreement. So there are several types of discharges, like discharge by performance, discharge by agreement, discharge by impossibility, discharge by breach of contract, and so on. So we will look into it at a glance. What are those? So discharge by performance. So termination of the contractual relationship between the parties. One party refuses to accept, then it is a termination of the contract, isn't it? So discharge by performance is attempted performance or tender, and accepted performance is there. Then at a glance, we will look into fast. Then discharge by agreement, there is novation is there, rescission is there, remission is there, alteration is there, like that. Then what? Waiver is there, and a merger is there. And discharge by impossibility of performance, impossibility known to the parties, impossibility not known to the parties, and third is what? Impossibility that arises subsequent to the formation of the contract, and impossibility that is knowing only to the promisor. So in these cases, impossibility that arises subsequent to the formation of the contract, that is called doctrine of supervening impossibility. There is a supervening power in that. Okay, so that is the doctrine of supervening impossibility. So that is the doctrine of supervening impossibility. Then there are some situations where the supervening impossibility to be effected. One is destruction of the subject matter itself. The subject matter, even it is destroyed, means it is not at all usable. In such a case, this doctrine of supervening impossibility persists. Then next is, what is that? Non-existence or non-occurrence of a particular state of affairs or state of thing. Non-occurrence, അത് നടക്കുന്നേ ഇല്ല, അല്ലെങ്കിൽ നോൺ എക്സിസ്റ്റൻസ്, നിലനിൽക്കുന്നേ ഇല്ല ആ ഒരു കേസ്. അതിന്റെ എക്സാമ്പിൾ വരെ കണ്ടതാണ് അല്ലെ, നമ്മൾ കിങ് എഡ്വാർഡിന്റെ പ്രൊസഷൻ. ആ പ്രൊസഷൻ നടക്കുന്നേ ഇല്ല, കാര്യം പുള്ളിക്ക് എന്തായി? അസുഖമായി. അപ്പൊ എന്താ, ഒരു റെന്റിന് ഒരു സ്ഥലം എടുത്ത്, നമ്മൾ കണ്ടതാണല്ലോ, റെന്റിന് ഒരു സ്ഥലം എടുത്തിട്ട് അവിടെ താമസിക്കുകയായിരുന്നു എച്ച്. അപ്പൊ എച്ച് hired a flat from K for watching that procession. Even if the procession is not at all occurred or not non-existence of that one, then H is not giving to pay any rent to K. That is the case. Clear? Then death or the personal incapacity of a person. Then change of law or stepping of a person with a statutory power. അതായത് സ്റ്റാറ്റ്യൂട്ടറി അതോറിറ്റി. അപ്പൊ നമ്മളൊരു സ്ഥലം പാട്ടത്തിന് എടുക്കുകയാണെങ്കിൽ ആ സ്ഥലം ഗവൺമെന്റ് എടുത്തെടുത്താൽ പിന്നെ നമുക്ക് അതിനോട് കാര്യമുണ്ടോ? അതാണ് നമ്മൾ ഇന്നലെ കണ്ട എക്സാമ്പിൾ. സോ ചേഞ്ച് ഓഫ് ലോ ഓർ സ്റ്റെപ്പിംഗ് ഓഫ് ഇൻ എ particular person with a statutory power. So government with a statutory power ulla idalle. And outbreak of the war. And also there are some exceptions: difficulty of performance, commercial impossibility, impossibility due to the failure of a third person, and self-induced impossibility, and the strikes, lockouts, and civil disturbances, and failure of any one of these above aspects. These are the exceptions to a doctrine of supervening impossibility. Supervening impossibility എന്ന് പറഞ്ഞാൽ തന്നെ എന്താണ്? അതിന്റെ സബ്ജക്ട് മാറ്റർ അല്ലെങ്കിൽ ആ ഒരു this one impossibility arises subsequent to the formation of the contract. അതായത് entering into the contract, after that this impossibility occurs. At that time this event is possible or happening. Event നടത്താൻ പറ്റുമായിരുന്നു ഏത് സമയത്ത്? ആ സമയത്ത്, isn't it? എന്നാൽ അതിനുശേഷം ആ ഒരു കോൺട്രാക്ട് നടക്കാൻ തന്നെ ബുദ്ധിമുട്ടാണ്. അതാണ് എന്ത്? സൂപ്പർവീനിങ് ഇമ്പോസിബിലിറ്റി. ക്ലിയർ? ദെൻ അതിന്റെ സിറ്റുവേഷനും അതുപോലെ അതിനുള്ള എക്സെപ്ഷനുമാണ് നമ്മൾ കണ്ടത്. നെക്സ്റ്റ് ഈസ് എഫക്ട്സ് ഓഫ് സൂപ്പർവീനിങ് ഇമ്പോസിബിലിറ്റി. the contract becomes void and the parties are under no obligation to perform the contractual duty. In such a case, this will occur. Supervening impossibility will occur. So the contract becomes void, means not valid. The contract becomes invalid, so that parties are under no right to do their obligation. Parties in no right or avagasham in order to do that thing. Clear? So that is this one effect of supervening impossibility. The contract becomes void and the parties are under no obligation to perform the contractual duty. And next is the person who has received any benefit under a contract which becomes subsequently void is bound to restore it. If any person is getting any benefit based on that and the contract becomes void, that person need to restore that benefit or compensate it to the person from whom he had received it. The person who received any benefit from any person or based on a contract, if any person receives any benefit at the time of the contract and later on the contract becomes void, then he is bound to restore it or do the compensation or to make the compensation to the person from whom he had received it. Compensation at the time of the contract, if he received that one, then it is okay. And later on, the contract becomes void. He needs to return it back. That's the second point, isn't it? The person who received any benefit under a contract that becomes subsequently void and is bound to restore it in order to make the compensation to the person from whom he had received it. Section 65. These are the effects with regard to the which one? Supervening impossibility. First is what? The contract becomes void and no party and the parties are parties have no right to do their duty or obligation. Section 56 para 2 of the Contract Act. Then section 65 of the Contract Act, if any person receives any benefit at the time of the contract and later the contract becomes void, the person who receives it shall restore it or to make a compensation from whom he received it. Isn't it? Then third is what? Where one person has promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful, the promiser makes compensation to the promisee for the loss occurred which the promisee sustains through the non-performance of the promise. അതായത് എയും ബിയും കൂടെ കോൺട്രാക്റ്റിൽ ഏർപ്പെടുത്തു. ഫോർ എക്സാമ്പിൾ, എന്തായാലും ഒരു കാര്യത്തിന് ബിക്ക് അറിയില്ലായിരുന്നു ബി ഇസ് ദ പ്രോമിസി ആൻഡ് എ ഇസ് ദ പ്രോമിസർ. So A promises to give some rupees to B for doing something. Okay, but that thing is impossible to do. That doesn't know by the promisee, but the promiser knows this one. And in such a case, if any loss occurred to the promisee, that should be benefited or compensated by the promiser. That is the next one. Isn't clear, student? അതായത് എയും ബിയും കൂടെ എന്തെങ്കിലും ഒരു കാര്യം ചെയ്യണം എന്നുള്ളത് എ ബിയുമായിട്ട് കോൺട്രാക്റ്റിൽ ഏർപ്പെട്ടു. ബട്ട് ബി ഇസ് ദ പ്രോമിസി ആൻഡ് ഹി ഡസന്റ് നോ ദാറ്റ് ഇറ്റ് ഈസ് ആൻ ഇമ്പോസിബിൾ ഐറ്റം ആൻഡ് എ ഈസ് നോയിങ് ദാറ്റ് ഇറ്റ് ഈസ് ഇമ്പോസിബിൾ ആൻഡ് ദ ഹാപ്പനിങ് ഓഫ് ദാറ്റ് തിങ് ഈസ് ഇമ്പോസിബിൾ. അത് ബുദ്ധിമുട്ടാണ് എന്നുള്ളത് ആർക്കറിയായിരുന്നു? എയ്ക്ക് അറിയായിരുന്നു. ബട്ട് ബി ഡസന്റ് നോ. ഇൻ ദ കേസ് ഓഫ് നോൺ പെർഫോമൻസ് ഓഫ് സച്ച് എ പ്രോമിസ്, if the B is having or B got any loss due to the non-performance of that contract, then A need to compensate it. That is the example for this. When one person has promised to do something that he knew or with a reasonable diligence might have known and which the promisee didn't know that it becomes impossible or unlawful, then the promiser shall compensate to the promisee for the loss occurred for the non-performance of the promise. Clear? So these are the effects of doctrine of supervening impossibility. Very important, supervening impossibility. Sure, it will ask the question. Ask as a question. Next is doctrine of frustration. What is that? Doctrine of frustration. Doctrine of frustration is the principle prevailing in England in the place of the concept of supervening impossibility applied in India. Indian supervening impossibility in the England doctrine of frustration. This doctrine is applicable when the common object of a contract can no longer be achieved, which is because impossible to do that thing. So, such a case, or when the contract after it is made becomes impossible of performance due to the circumstances beyond the contemplation of the parties. So, it is not under the control of the parties. Parties in the control alla, either and the happening of that event is impossible. At the time of the contract, it is possible, but later on it becomes impossible. That is called doctrine of frustration, and it is not with the parties also concerned. So that is the doctrine of frustration. So once again, doctrine of frustration is the same that is to be prevailing in India, the doctrine of supervening impossibility, and it is to be followed in England in the place of the concept of supervening impossibility applied in India. So this principle is in England, and the doctrine of this one, when the common object of a contract can no longer be achieved, it cannot be achieved, sure. So, or when the contract after it is made, contract it becomes possible. Later on, notice that it is impossible, then the performance due to the such a circumstances beyond the contemplation of the parties. It is not under the control of the parties involved. That's a doctrine of frustration, and it is to be followed in England in the same place, the doctrine of supervening impossibility that is to be applied in India. Students, now you know doctrine of impossibility frustration is the same as doctrine of supervening impossibility. Okay, clear? So we see discharge by performance, attempted and accepted. Discharge by excuse me, discharge by agreement, novation, rescission, remission, alteration. Then what is that? Waiver, merger. Then discharge by impossibility of performance, impossibility due to the happening of an event that is known to the party and not known to the party, and happening of an event that is after the starting of the contract. That is the supervening impossibility. And there are situations and exceptions also, isn't it? And the factors that affecting the doctrine of supervening impossibility and doctrine of frustration, that is to be followed in England in the same place whether applied by this doctrine of supervening impossibility in India. So we already see what three types: discharge by performance, termination of the contract by performance, termination of the contract by agreement, and termination of the contract by impossibility of the happening of the event. Next is discharge by operation of law. Discharge by operation of law. So what is this? Other Niyaprakaram termination undaga. Okay. By the death of a person, by the insolvency of a person, insanity of a person, or the unauthorized alteration of a person. So a contract may be discharged by operation of law as due to the situations: by the death of the parties, by the insolvency of the party, and unauthorized alteration. So by the death. In case of contracts involving personal skill or ability, the contract is terminated on the death of the promisor. ഒരു പ്രോമിസറുടെ ലീഗൽ ഹെയർസ് ഉണ്ടെങ്കിൽ ഉണ്ട്, ഇല്ലെങ്കിൽ പറ്റില്ല. സോ പ്രോമിസറുടെ ഡെത്തോടുകൂടി ഒരു കോൺട്രാക്ട് ടെർമിനേഷൻ ആയി പോകും. എന്തുകൊണ്ട്? ഇൻ കേസ് ദ കോൺട്രാക്ട്സ് ഇൻവോൾവിംഗ് ദ പേഴ്സണൽ സ്കിൽ ഓഫ് ഓർ എബിലിറ്റി ഓഫ് ദ പ്രോമിസർ. In such a case, termination of the contract is with the death of that particular promiser. So due to the death, then due to insolvency. When a person is declared insolvent and an order of discharge is passed against him, he is released from all the liability. He will be released from all the past liability. അതായത് പൈസ ഇല്ലാന്ന് ഇൻസോൾവെന്റ് ആയിന്ന് കാണിച്ചുകൊണ്ട് ഒരു ഇതാണെങ്കിൽ he will be released from all the liability. So that is the second case by insolvency. Then by unauthorized alteration. Any material alteration of a written contract made without the consent of the other party has the effect of discharging the contract. ഒരു പാർട്ടിയുടെ സമ്മതമില്ലാതെ മറ്റേ പാർട്ടി any alteration to be done in the contract, present contract any alteration to be made, then in such a case it should be terminated. So by the death, by the insolvency and unauthorized alteration. So that is the discharge by operation of law. Then another one, discharge by lapse of time. സമയം കഴിഞ്ഞു എന്നുള്ളതിന്റെ വെച്ച്. So the Limitation Act 1963 lays down the duration within which an affected party has to file a case. If a contractual obligation is not performed by the promiser and no legal action is taken by the promisee within the period of limitation, he is deprived of his remedy at law. For all practical purposes, the contract has got the effect of termination. For example, the period of limitation to file a case to recover the money is usually 3 years. 3 വർഷത്തിനുള്ളിൽ പൈസ തിരിച്ചു കിട്ടണമെന്ന് പറഞ്ഞുകൊണ്ട് കേസ് കൊടുത്താലേ എന്തുള്ളൂ ആപ്ലിക്കബിൾ ഉള്ളൂ, ഇല്ലെങ്കിൽ കിട്ടില്ല. If within 3 years the creditor fails to file a suit to recover the amount, the debtor is discharged from that liability. പിന്നെ തിരിച്ചു കൊടുക്കേണ്ടേ വരില്ല. കാര്യം ആ 3 വർഷത്തിനുള്ളിൽ കേസ് കൊടുത്തിരിക്കണം. Otherwise, no need to pay anything from the debtor to the creditor. So that is the due to the lapse of time. സമയം കഴിഞ്ഞു പോയി ആ കോൺട്രാക്ട് ടെർമിനേഷൻ ആയി പോകും. ഇപ്പൊ വിത്തിൻ ഒരു പർട്ടിക്കുലർ ടൈം പീരീഡ് കൊടുത്തിട്ടുണ്ടാവും. Okay, so that is by the discharge by the lapse of time. So once again, the Limitation Act 1963 lays down the duration within which an affected party has to file a case. If a contractual obligation is not performed by the promiser to do the act to the promisee, and no legal action is taken by the promisee within which the period of limitation, he is deprived from the remedy of law. അതായത് നിയമപ്രകാരം പിന്നെ സമയത്തിനുള്ളിൽ promisee ഒരു ആക്ഷനും എടുത്തിട്ടില്ല എങ്കിൽ then what is the issue? He is deprived or discharged from any liability. The promiser is free to not to pay anything. He is free from all these things. So that is the case. Example പറഞ്ഞതാണ്, ഒരു ഡെറ്റർ ക്രെഡിറ്റർ തമ്മിലുള്ള റിലേഷനിൽ ക്രെഡിറ്ററുടെ കയ്യിൽ നിന്ന് ഡെറ്റർക്ക് ഡെറ്ററുടെ കയ്യിൽ നിന്ന് ക്രെഡിറ്റർക്ക് എന്ത് പൈസ തിരിച്ചു കിട്ടുന്നില്ല എങ്കിൽ, അല്ലെങ്കിൽ തിരിച്ചു കിട്ടുന്നില്ല 3 വർഷത്തിനുള്ളിൽ കേസ് കൊടുത്താൽ ഇറ്റ് ഈസ് ഓക്കെ. അതർവൈസ് the debtor will be free of discharge. So that is the discharge by lapse of time. Then next is discharge by breach of contract. Discharge by breach of contract. Breach of contracts means breaking the contractual obligation by a party to the contract without a lawful excuse. നിയമപ്രകാരം ഒരു എക്സ്ക്യൂസ് പറയുന്നില്ല, അതേസമയം നിയമപ്രകാരം ഒരു ഇത് പറയുകയാണെങ്കിൽ ഓക്കെ, ഇറ്റ് ഈസ് ഓക്കെ എന്ന് പറഞ്ഞാൽ വയലേഷൻ ആകും. ബ്രീച്ച് ഇൻ ബിറ്റ്വീൻ എന്നുള്ളതാണ്. കോൺട്രാക്ടിന്റെ സമയപരിധിക്കുള്ളിൽ, ആ സമയത്തിനുള്ളിൽ നിന്നുകൊണ്ട് ഇങ്ങനെ ഒരു ഇത് ചെയ്യുകയാണെങ്കിൽ ഇറ്റ് ഈസ് ഓക്കെ. അതർവൈസ് ഇറ്റ് ഈസ് ഓൾസോ എ ടെർമിനേഷൻ. സോ ബ്രീച്ച് ഓഫ് കോൺട്രാക്ട് മീൻസ് ബ്രേക്കിംഗ് ദ കോൺട്രാക്ച്വൽ ഒബ്ലിഗേഷൻ ബൈ എ പാർട്ടി ടു ദ കോൺട്രാക്ട് വിത്തൗട്ട് ലോഫുൾ എക്സ്ക്യൂസ്. നിയമപ്രകാരം അല്ലാത്ത, without lawful excuse, if any person makes a breaking of the contractual obligation or the contractual duty by a party to the contract. So the promisor makes a breaking the contractual obligation to do that thing, and the promisee is not accepting, and promisee accept, then okay, but without a lawful excuse. With a lawful excuse, then it is okay. So without a lawful excuse, then breaking the contractual obligation by a party to the contract, it is the discharge by the breach of contract. When a party to a contract fails to perform the obligation imposed upon him, he is said to have committed a breach of contract. So when a party to the contract fails in performing the duty to be performed, then what is the issue? He is said to be breach of contract, violating the contract. Violation is there. So breach of contract is of two types: actual breach and anticipatory breach. Yathartha breachum anticipatory എന്ന് പറഞ്ഞാൽ estimation അല്ലെ anticipate ചെയ്തുകൊണ്ടുള്ള ഇത്. So what is this? Actual breach of contract and anticipatory breach of contract. അപ്പൊ breach of contract എന്താണെന്ന് മനസ്സിലായല്ലോ? Contractual obligation നടത്താതിരിക്കുക അല്ലെങ്കിൽ അതിനകത്ത് violation നടത്തുക. That is not to perform his duty within the stipulated time. അതാണ് breach of contract പറയുന്നത്. അപ്പൊ അങ്ങനെയുള്ള ഡിസ്ചാർജ് ആണ് discharge by breach of contract. So actual breach of contract and anticipatory breach of contract. Actual breach may take place either at the time when the performance of the contract is due and during the performance of the contract. At the time when the performance is due, അതായത് കോൺട്രാക്ടിന്റെ പെർഫോമൻസ് ഡ്യൂ ആയി നിൽക്കുന്നു അല്ലെ ഇതിന്റെ ഇടയ്ക്ക്, അതാണ് ആക്ച്വൽ ബ്രീച്ച് ഓഫ് കോൺട്രാക്ട്. സോ at the time when the performance of the contract is due, when a person does not perform the obligation at the time when it is due, it is an instance of actual breach of contract. യഥാർത്ഥത്തിൽ പെർഫോമൻസ് ഡ്യൂ ആണ്, to do that duty. In order to do that duty and he is not doing the duty, then it is actual performance, actual breach of contract at the time when the performance is due. Clear? എന്തെങ്കിലും ഒരു കാര്യം ചെയ്യാനുള്ളതാണ്, പക്ഷെ ആ സമയത്തിൽ ചെയ്യുന്നില്ല എങ്കിൽ what is that? It is the performance of the contract that is due and the person is not doing that one. That is actual performance or actual not performance, actual breach of contract. ഇനി and രണ്ടാമത്തെ കേസ്, during the performance of the contract. During the performance of the contract, if one party to the contract fails to perform its obligation under the contract, it is an instance of actual breach of contract, and the refusal to perform the contractual obligation may be communicated expressly or it may be implied from the conduct of the party. So what is that? During the performance of the contract, if one party of the contract or to the contract fails to perform the duties under the contract, it is an instance of actual breach of contract. അപ്പം മറ്റേതോ at the time when the performance is due, then if anybody violates to perform it, it is a discharge of actual breach of contract. ഇനി അതിന്റെ രണ്ടാമത്തെ ഭാഗം, during the performance of the contract പെർഫോം ചെയ്യുന്ന സമയത്തുള്ളത്. Okay, during the performance of the contract, if one party to the contract fails to perform the duty under the contract, it is an instance of actual breach of contract. It refuses to perform the contractual obligation that may be communicated expressly or impliedly by the conduct of the party. അതായത് പാർട്ടിയുടെ കോൺടാക്ട് പെരുമാറ്റം അതിൽ കൂടി expressly or impliedly, that you see in the first module or first unit, express contract and implied contract. So the contractual obligation, the duty to be performed. Okay, so in such a case, the refusal to perform such an obligation that is not to be performed, that may be communicated expressly or impliedly by the conduct of the parties. Conduct of the parties. So this is actual breach of contract when the performance is due and during the performance. If anybody violates to perform, it is treated as actual breach of contract. So actual breach and anticipatory breach. Actual breach and anticipatory breach. So if a party to a contract repudiates means cancelled, okay, repudiates or renounces his obligation before the time fixed for performance, it can be treated as anticipatory breach of contract. The repudiation may be by expressly renouncing his obligation under the contract or by doing some act so that the performance of his promise becomes impossible. So, what is anticipatory? Before performing the contract, before the time fixed for the performance, he renounces or repudiates his obligation, means cancel his obligation or not to do that duty. That is what anticipatory breach of contract. So, such a repudiation may be expressly renouncing his obligation that is under the contract or by doing some act so that the performance becomes impossible. അപ്പോൾ എന്തെങ്കിലും പ്രവൃത്തി കൊണ്ട് ആ പെർഫോമൻസ് ഇറ്റ് ഈസ് നോട്ട് പോസിബിൾ ടു ഡു, അങ്ങനെ വരുന്ന കേസ് ആണെങ്കിൽ ഇറ്റ് ഈസ് ആന്റിസിപ്പേറ്ററി. സോ ആക്ച്വൽ ബ്രീച്ച് ഓഫ് കോൺട്രാക്ട് ആൻഡ് ആന്റിസിപ്പേറ്ററി breach of contract. Next, remedies to such anticipatory breach. The promisee has two options in the case of an anticipatory breach. Hope you know what is anticipatory breach and actual breach. Actual എന്ന് പറഞ്ഞാൽ യഥാർത്ഥത്തിൽ So, actual breach എന്ന് പറഞ്ഞാൽ എന്താണ്? യഥാർത്ഥത്തിൽ ആ ഒരു പെർഫോം ചെയ്യുന്നതിന് തൊട്ട് മുന്നേ അത് ബ്രീച്ച് വയലേഷൻ നടക്കുകയാണെങ്കിൽ, അല്ലെങ്കിലോ എപ്പോഴാണ്? ഡ്യൂറിംഗ് ദ പെർഫോമൻസ് ഓർ at the time the performance is due, the violation occurs. That is the actual breach of contract. And anticipatory breach of contract means what? That is, if the time fixed for the performance before that this person to do the obligation or the duty repudiates to do, or what is that? Not to do or cancel his performance, such a case anticipatory breach of contract. And what are the remedies with regard to the anticipatory breach of contract? He can treat the anticipatory breach as actual breach and sue the party in default for damages without waiting for the actual date of performance. അങ്ങനെ വരുമ്പോൾ ഇവിടെ പറഞ്ഞത് പെർഫോമൻസ് ഡേറ്റിന് മുന്നേ ക്യാൻസൽ ചെയ്യുന്നു. അപ്പോ എന്തെങ്കിലും നഷ്ടം വരികയാണെങ്കിൽ the other party can sue against this person because he face a lot of loss due to such non-performance. അപ്പൊ അതാണ് പറഞ്ഞത്, he can treat the anticipatory breach as actual breach of contract. യഥാർത്ഥത്തിൽ നടന്നിട്ടില്ല എന്ന് തന്നെ കാണിക്കാം. Isn't it? അതാണ് ആന്റിസിപ്പേറ്ററിയും ആക്ച്വലും തമ്മിലുള്ള വ്യത്യാസം. ഇത് നടക്കുന്നതിന് തൊട്ട് മുന്നേ തന്നെ, നേരത്തെ തന്നെ എന്ത് ചെയ്യുന്നു? ക്യാൻസൽ ചെയ്യുന്നു. അതാണ് ആന്റിസിപ്പേറ്ററി ബ്രീച്ച് ഓഫ് കോൺട്രാക്ട്. അപ്പോ ഇവിടെ നടന്നിട്ടുണ്ട് എന്നുള്ള രീതിയിൽ എന്ത് ചെയ്യാം? കാണിക്കാൻ പറ്റും. ദാറ്റ് ഈസ് ആക്ച്വൽ ബ്രീച്ച് ആയിട്ട് കാണിച്ചിട്ട് he can sue against the other party for the damages occurred due to the non-performance. Clear? അതാണ് ഒരു റെമഡി. അതിനെ ആന്റിസിപ്പേറ്ററി ആണെങ്കിൽ അതിനെ ആക്ച്വൽ ആക്കി കാണിച്ചിട്ട് എന്ത് ചെയ്യാം? he can sue against the damages occurred. And he may treat the contract as subsisting and wait till the date of performance and then avail legal remedies for the breach of contract against the defaulting party. So he may treat the contract as subsisting, നിലനിൽക്കുന്നതാണ് എന്ന് ഇപ്പോഴും കാണിക്കുക. He may treat the contract as subsisting and wait till the date of the performance. എന്നുവരെയാണ് അതിന്റെ ഡേറ്റ് പറഞ്ഞിരിക്കുന്നത്. So wait till the date of the performance and avail legal remedy എന്ന് പറഞ്ഞാൽ നിയമപരമായിട്ട് നീങ്ങാൻ പറ്റും for the such a breach against the defaulting party. അതായത് ആരാണോ തന്റെ ഇത് പെർഫോം ചെയ്യാൻ മടിച്ചത് അല്ലെങ്കിൽ പെർഫോം ചെയ്യാതിരിക്കുന്നത്, അതായത് ആ ഒരു കോൺട്രാക്ട് നിലനിൽക്കുന്നുണ്ട് എന്ന് കാണിക്കുക. Treat the contract as subsisting means still live and wait till the date of the performance and thereby availing legal remedies for the breach against such a defaulting party. So these are the discharge of performance. So, or discharge of contract, discharge by performance, attempted and accepted performance, discharge by agreement. What is that? Novation, remission, rescission, alteration, waiver, then merger. And anything is there else? And then discharge by the impossibility, happening of an event that is not knowing, and also knowing to the promiser, and also after the performance of the contract or after entering into the contract, the discharge occurs, or the impossibility occurs. That is doctrine of supervening impossibility. There is some situation with regard to, as well as there are exceptions with regard to the doctrine of impossibility and the effects of doctrine of impossibility. And also one more thing is doctrine of frustration, like the same doctrine of impossibility that is applied in India, the doctrine of frustration applied in UK, England. Okay, like the same, there is a same clause all there in the doctrine of frustration. Then we see the discharge by the lapse of time, discharge by the breach of contract, discharge by the operation of law. These are the then discharge by the operation of law due to the death of a particular person, due to the death of the particular person who promised to do that thing, or insolvency by a person, or unauthorized alteration within the already maintained contract. ചിലപ്പോൾ അത് accepted ആയിരിക്കില്ല മറ്റേ പാർട്ടിക്ക്. അതാണ്. So under the operation of law, by death, by insolvency, and by unauthorized alteration, then discharge by the lapse of time. സമയത്തിനുള്ളിൽ ചെയ്ത് തീർത്തില്ല എങ്കിൽ. Then discharge by the breach of contract, where actual and anticipatory breach of contract are there, and actual contract where what it happens actually at the time of performance, due or during the performance. In both the cases, what is that? Actually there is a breach of contract, so that maybe can sue against the other party, isn't it? While anticipatory breach of contract, the remedies with regard to is maybe it is treated as actual contract and may sue against the damages occurred due to the non-performance. And second is what? Second remedy is what? Still it is still alive or subsisting. The contract is subsisting, showing as subsisting, and wait till the performance of the contract by the parties, so that he can sue against the party or the defaulting party, the damages occur. So this is the discharge of contract. So discharge by performance, discharge by agreement, discharge by impossibility, discharge by the operation of law, discharge by the breach of contract, and discharge by lapse of time. So hope you enjoyed the class, and please let me know if anybody is having any doubt with this. Clear as soon as possible the doubts. And with that, we come to the end of unit number 10. And next class, we will start unit number 11 of the module number 1. And thank you for the day.